Hello everyone, welcome back to our channel Legal Nexus. In today's video, we are going to talk about a very interesting topic, Christian succession. Christian succession in India is mainly governed by Indian Succession Act 1925, which lays down the rules relating to how the property of deceased Christian person is distributed among their heirs. Testamentary and intestate succession for Christian in India is regulated by Indian Succession Act 1925. The Act also applies to persons celebrating marriages under the Special Marriage Act 1954. But if both parties are Hindus, then Hindu Succession Act 1956 will apply even if they celebrate the marriage under the Special Marriage Act. Special Marriage Act, it came into effect amended of the Act 1976. Rule of Succession, Section 31 to 49. A person can dispose of property by will, but if he has not done so, then rules of succession will be applied. The heirs who are entitled to succeed to the property are relation of kindred. They are divided into kindred by lineal consanguinity and kindred by collateral consanguinity. Kindred by lineal consanguinity, they are son, son's son, or daughter, daughter's daughter, and the like in descending order. One's own father, father's father, and like in ascending order. Every generation constitutes a degree either ascending or descending. Father is in the first degree of ascending, and son is in the first degree of descending. Kindred by collateral consanguinity. They are brothers, sisters, and uncles and aunts, and like father's descendant, mother's descendants, father's father's descendant, mother's mother's descendant, and like. Husband and wife. Rule 1. Husband or widow will inherit 1/3 if there is a lineal descendant or descendants. Rule 2. Husband or widow will inherit half if there is no lineal descendant but there are or is other kindred such as father, brother, mother, and like. Rule 3. Husband or widow will take the whole of the property if there is no relation either of lineal consanguinity or collateral consanguinity. Sons or daughters. Rule 1. If the husband or wife is alive, first give their 1/3 and remaining 2/3 is divided among sons and daughters equally. Rule 2. If the husband or wife is not alive or when both are dead, then the whole of property will be divided between sons and daughters equally. Grandchildren and children. Rule 1. Son and daughters get equal portion if one or more of the sons or daughters were died leaving his or own descendants, then they are entitled to inherit the respective capacity of their own father or mother. In the famous case Mary Roy versus State of Kerala, Mary Roy and others have filed writ petition before Supreme Court impleading the State of Kerala and others under Article 32 of Constitution of India. The petitioners challenged the constitutional validity of the Travancore Christian Succession Act 1092 on the ground that several provisions of the Act were violative of Article 14 and 15 Clause 1 of Constitution of India. Prior to July 1949, the state of Vancouver was a priestly state. This law in force in the territories of the state in regard to interstate succession to the property of members of Indian Christian community was the Travancore Christian Succession Act 1092. This act was promulgated by His Highness the Maharaja of Travancore with a view to consolidate and amending the rules of law applicable to interstate succession among Indian Christians in Travancore. Thus, the Travancore Christian Succession Act 1092 was automatically repealed. So, the Supreme Court held that there is no necessity to declare an unconstitutional and void since it is incorporative. The result of this decision is that the Indian Succession Act 1925 shall be deemed to have come into force Travancore Cochin area from 1st April 1952, and thus the daughters shall have equal right with sons for the purpose of succession of property of the father. Will. When a person dies without Executing a will or testament, his heir or heirs, according to the personal law, may succeed to the property left behind by the deceased owner, also called propositus. This situation led to interstate succession. If the deceased is a Hindu, the Hindu Succession Act 1956 will govern. If the deceased Muslim, the Muslim law of inheritance will be applicable. If the deceased is a Christian, the Hindu Indian Succession Act 1925 will be applicable. The owner can very well make a declaration as to how his property should be disposed of on his death. Then he is said to have executed a will or testament. The maker of will may be referred as testator. This situation led to testamentary succession after his death. The person whom the testator has bequeathed the property in whole or part is called legatee, and the property is called legacy or bequest. In India, the provision relating to execution and attestation of wills by Hindus and Christians are contained in Indian Succession Act 1925. The provision of Hindu Succession Act relating to the execution and attestation of wills are not applicable to Muslims. However, the provision in the Indian Succession Act relating to the probate of will, letter of administration and succession certificate are applicable to Hindus, Christians and Muslims. Definition of will and codicil. Section 2 Clause H of Indian Succession Act 1925 define a will as legal declaration of the inheritance of a testator with respect to his property which the decide to be carried into effect after his death. Every person of sound mind, not being a minor, may dispose of his property by will. A will is take effect after the death of testator. A will may be revoked or altered at any time during the testator's lifetime as long as he is competent to dispose of his property by will. There can also be a codicil by Section 2 Clause B of the Act of Codicil. Codicil means an instrument made in relation to a will and explaining, altering or adding to the form part of will. A will or any part of a will, the making of which has been caused by fraud or coercion or by such importunity as taken away the free agency of the testator is void. Will can be divided as privileged wills and unprivileged wills. Privileged wills are those made by soldiers engaged in war, airmen, so employed, and mariners at sea. Any other will is an unprivileged will. Unprivileged wills are more in practice. Mode of making privileged wills. A soldier who is employed in an expedition or engaged in actual warfare, or an airman so employed or engaged, or a mariner who is at sea may, if he has completed the age of 18 years, dispose of his property by a will. Such wills are called privileged wills. Privileged wills may be in writing or may be made by words of mouth. Revocation of privileged will. A privileged will may be revoked by the testator by an unprivileged will or by any act expressing an intention to revoke it and accompanied by such formalities as would be sufficient to give validity to a privileged will, or by the burnings, tearing or otherwise destroying the same by the testator or by same person in his presence and by his direction with the intention of revoking the same. Revocation of unprivileged will. By Section 17, a unprivileged will may be revoked by different means. They are briefly given below by subsequent will or codicil. If a later will or codicil contain a clause revoking the previous will, or if it makes disposition so inconsistent with the earlier will that the two cannot stand together, The previous will stands revoked. By instrument of revocation, a will may be revoked by some writing declaration and intention to revoke the executed in manner in which a will is required to be executed. By destruction of will, destroying a will with the intention of revoking it is another mode of revocation. The destruction must be with the amino revocandi. The destruction must be so effected by the testator or by someone on his behalf in his presence under the destruction of testator. By subsequent marriage of testator, if a person had prior to marriage executed his will, the effect of the marriage is to revoke the will. This is revocation by operation of law. So that's all about Christian succession under the Indian Succession Act 1925. We learn how properly is distributed among heirs when a Christian person dies and how the act ensures a fair division between the widow children and other relatives. Remember, succession can be either testamentary or intestate depending on whether a person leaves a valid will or not. If you found this video helpful, don't forget to like, share and subscribe to more legal insights.